This hearing will come to order. Good morning. I am Jackie Tucker, Chair of the Sycuan Gaming Commission. On behalf of the Commission, I would like to welcome everyone to the third and final day of our regulatory fact-finding hearing. For those of you who are here for the first time, I would like to introduce the Commission and staff. Commissioner Cornette Pettiford, Alternate Commissioner Charlene Eckel, Executive Director Yvonne Atkins-Payne, Director of Regulations Ed Magdaleno, Tribal Attorney George Foreman, and hearing consultants Mr. Joe Valandra, Michael Lombardi, Jess Green, John Plata, Joe Webster, Linda Metrovich. Our first panel today is the Class II Gaming Tribal Regulators Panel. Mr. Michael Lombardi, Gaming Commission Chairman, Augustine Band of Cahuilla Indians, Mr. Jamie Hummingbird, Director, Cherokee Nation Gaming Commission and the National Tribal Gaming Commissioners Regulators, Ms. Nancy McAllister, former Commissioner, Eastern Shawnee Gaming Commission, currently at Green Law Firm, and Mr. Jerry Schultze, Executive Director, Morongo Band of Mission Indians Gaming Commission. Please come forward. Welcome. We will begin with Mr. Lombardi.
Good morning, Commissioners.
Good morning.
Great to see you again. By way of getting into my comments, I wanted to just give you a little bit of my background so that you would understand the perspective that I bring with me in the endeavors that I'm currently engaged in as the chairperson of the Augustine Gaming Commission. I've held that position for the last 4.5 years. From 1978 until 1988, I ran a nonprofit community center in South Central Los Angeles. My primary source of funding was a charity bingo game. Operated on Saturday and Sunday afternoons at the Big John Monomaliuna Community Hall. That program supported our high-risk youth, gang diversion programs, and South Bay Indian services. I learned the bingo business in a Samoan church, working the floor and doing every single job that is associated with bingo. In 1988, I became the general manager of what was at that time known as Morongo Indian Bingo. It would become Casino Morongo. During my period as a general manager, I was confronted with enormous competition in the Indian bingo market. We had Cabazon to the south and the huge and successful San Manuel Bingo to the west. In order to keep our facility open and keep the 76 tribal members that were gainfully employed there at that time, matter of fact, those were the only jobs on the reservation, that and the Cattlemen's Association, we engaged in a number of innovative bingo games similar to bingo and introduced Fortunette. Fortunette Morongo was the first gaming operation in the world to offer a computerized card play system that allowed players to play up to 256 cards on a terminal. That would grow into a multi-billion-dollar industry today, and I'm proud to say Morongo was the first to ever play video bingo in the United States. We also introduced, with the help of the Oneida Nation of Wisconsin, 113 video pool tab games. Were enormously successful, along with Verona. Morongo and Verona were the first two tribes in the state of California to introduce Class II video pull tab games. We also, in conjunction with the Turnip Seed family in Tacoma, Washington, introduced Bullet Bingo to California that would be immediately expropriated by the San Manuel Band and turned into Lightning Bingo, which became an enormously successful table game. I'm proud to say that I've been involved in a number of innovations in the California Indian gaming industry. After leaving Casino Morongo, I went to work for Gamma International and traveled around the country visiting Indian tribes and consulting with their bingo managers in New Mexico and Florida and Arizona, California, Oregon, and Washington. It was a great experience. In 1993, I went to work for the Shumash tribe. We reopened their bingo hall. I was the general manager of Shumash Casino until 1998. When I left, I went out to Oklahoma and spent some time with a very good friend of mine, Tracy Burris, who was the gaming commissioner of the Chickasaw Nation, and spent a considerable amount of time in Oklahoma. Tracy has had more to do with my introduction to tribal regulation than probably any other person in the country, and I want to publicly thank him today, who's at home with his wife in Oklahoma and is ill, but sends greetings to everyone here. My comments regarding gaming regulation are tempered by the fact I've been in operations. I've been a general manager of 2 Indian casinos and a charity bingo, and have served for the last 4.5 years as the chairman of the Augustine Gaming Commission, located just a few minutes away from the Salton Sea. Matter of fact, we're so close to the Salton Sea you can smell it. Let me say that at Augustine we have identified 5 strategic objectives that our Tribal Gaming Commission is charged with and responsible to the tribal government. Our first responsibility at the Augustine Gaming Commission is licensing key management, taking applications, conducting investigations, sharing that information with the National Indian Gaming Commission and the Bureau of Gambling Control. Asset protection is one of our primary objectives, which includes auditing. We have an internal auditing unit that works every single day in conjunction with our Certified Public Accountant Agency, E.J. Egerhart, to make sure that every single dollar that is taken in at the Augustine Casino ends up at the bank and in the tribal treasury. Game integrity protection, making sure that the guests, our California citizens that come to our nation and play our video games and our table games, are playing games that are fair and operated with the highest level of integrity. Nothing is more important to our brand name than the trustworthiness of the games that we offer our customers. We also conduct hearings in conjunction with customer disputes. We don't have very many of them, but when we do, we have a due process mechanism where players can have their complaints or their concerns addressed by an independent body. And game determination. I will say that Augustine currently operates 800 Class 3 devices. We have been doing a survey because we are very interested in getting into Class 2 gaming. This hearing has been enormously helpful to me as I prepare myself for developing a process where the Augustine band can begin to make determinations on, regarding Class 2 games that various vendors have been presenting to us. I would like to offer to this commission the results of my research as part of my testimony that includes what I call the 10 best practices to date that various tribal gaming commissions that I have conferred with, studied, talked to, employ when attempting to determine if a game that a vendor is interested in placing into our facility in fact meets the criteria of a Class 2 game. This does not mean that every tribe uses all of these practices. Some may do 2 or 3, some may do all of them. But let me offer them to you for your consideration. The first thing most tribal gaming commissions that I've talked to do is they ask the vendor to provide them with a game, the actual physical game, the hardware and the software, so that they can examine it themselves, so that they can play it, so that they can investigate it and ask questions about it. So we've had vendors actually bring games to our facility, set them up, run them, play them, let us touch them, listen to what they have to say, open up the machine and look at the internal components. We confer with experts. We're constantly on the phone talking to legal counsel, talking to other tribal gaming commissions. The third best practice that we've identified is independent laboratories. We had a labs yesterday testifying as to the services that they provide. We generally speaking have been using GLI. We adopted all of their technical standards regulations when we first opened, and independent laboratory opinions and analysis have been vitally important to us in assisting in making determinations about which games we may want to place on our floor when we open our Class 2 pavilion. We, of course, confer with tribal legal counsel. essential. Our tribal attorney is Les Marston. He's a Kiowa that practices out of the state of New Mexico, and we've had extensive consultations with him. We request legal opinions from vendors. Most vendors acquire legal opinions from legal counsel that address the legal rationale as to why each respective vendor assumes that the game that they're presenting to us actually meets the criteria of a Class II game. One of the other best practices that we have identified is examining existing legal decisions leading to the establishment of case law. Yesterday's panel was enormously helpful to me in looking at the 9th, 10th, and 11th Court of Appeals decisions that have established parameters that seem to me to be easy to discern, and those legal opinions have been vitally important to us. We look at bodies of existing regulations for guidance. I've conferred with a number of other tribes who've shared their tribal ordinances with me that are engaged in Class II gaming. And of course, we spend quite a bit of time on the NIGC website looking at all of their publications. As I stated before, perhaps one of the most important best practices is conferring with other tribal regulatory agencies. Nothing is more important than reaching out and talking with those tribes who have long track records in this area, and I want to personally thank a number of tribes, including Creek Nation and Chickasaw Nation in Oklahoma, for having been most helpful in sharing all of their information. We do surf the web. There's lots of good stuff out there on the web. I want to compliment Hobbs Strauss. I think they have, of all the law firms that we've accessed, they probably have the best website on Class II gaming. Everything resides there that you would ever want to see in terms of existing case law. The NIGC website, as I mentioned, has also been enormously useful to us. And there's a lot of good information on there too for those of you who want to read and study more about Class II gaming. And I added this yesterday after hearing Attorney Jess Green talking, because we do this, and I think that seeking committee, I've heard that word, and I'm not a lawyer, I go, huh. That means seeking things in common with another party, I believe. And we certainly have done that with the Bureau of Gambling Control. We've had a number of conversations, particularly with Perry Dominy. I want to thank him for his openness, and also members of the California Gambling Control Commission that have shared vital information about the subject of Class II. So we do seek to consult with and talk with state regulators as well. So let me just end my remarks by focusing again on what I think of those 10 best practices that tribes engage in is the most important, and that would be conferring with other tribal regulatory agencies. Everything I am as a tribal gaming commissioner has come about because other tribal regulators, men and women, people far more knowledgeable than I, have opened up their hearts and their minds and shared with me what is most important to them. I'm an active member in the California State Tribal Network of Tribal Regulators. As you know, that network has kind of grown out of the Tribal State Association that is actually mentioned in the Tribal State Compact. Your next witness is a hero of mine. He heads what I believe is one of the most important organizations in the United States, which is a group of tribal regulators nationwide. And I think all of us should support Jamie Hummingbird in his efforts to create unity among tribal regulators nationwide. There are regional organizations as well. They have one in Oklahoma. They've been enormously helpful to me. And throughout the state of California, there's subgroups. Here in San Diego, I believe you have a group of regulators, particularly in the surveillance area, that meet regularly to share information. There's a group like that also in the San Joaquin Valley, made up of tribes in Central California that meet regularly. Nothing could be more important to you as tribal gaming commissioners in getting the information you need to facilitate the important decisions you have to make than talking to other regulators. And let me end my comments by saying this. After having spent 22 years in the Indian gaming industry and seen our successes and our failures, clearly what we have achieved could not have been done without solidarity and unity of purpose among tribes. When we are unified, when we act together as one, we are powerful. Indeed, the entire history of Indian nations in the United States is defeats brought by divisions among our tribes. It's an unfortunate reality in the history of Indian people in the United States that our peoples, various peoples, fought against each other and killed each other for the Europeans. We should learn from history. Unfortunately, in some jurisdictions, some tribes who compete against each other in the business world have taken that competition to new heights and new levels. And we should have learned that the federal government and the state government will take advantage of every opportunity to divide and conquer our people. So acting in unity, in solidarity, and settling our differences among ourselves and moving forward is in the best interest of our children. I'll close with this. My wife is a member of the Morongo Band. She comes from a long-honored family. Her grandmother was Ramona Lugo, who is the model of the woman that appears in the novel Ramona. We have a daughter who is 16, who is a daughter of Morongo and an enrolled member of the Morongo Nation. Every day I go to work, I think about her and her nieces and nephews and my daughter's cousins. One day they will grow up and become adults, and they will take their rightful place in our tribal gaming commissions and our business councils. We have a sacred obligation to make sure that the sovereign rights to administer civil regulatory codes of laws on our lands is preserved, and that they're going to get to be as sovereign as you are today. We're not here to give away their rights. We're here to protect those rights so that we can hand them off to them when their time comes. Thank you very much for the opportunity to speak to you during this important hearing.
Thank you, Mr. Lombardi. Mr. Hummingbird?
Thank you, Madam Chair. Commissioner Pettiford and alternate Commissioner Eckel, I want to commend you on a very well-planned and executed regulatory fact-finding hearing. It's been very beneficial to me, as I'm sure it has been very beneficial to others. We'll present some oral testimony today, and we'll follow that up with some written testimony at a later date. Just by way of introduction of myself, I am a graduate of Northeastern State University, where I received a degree in finance, and I have been in service to my tribe, the Cherokee Nation, for the past 17 years. And I've had the ability to work in a variety of capacities, including in accounting, self-governance, and the Chief of Staff's office. 11 of those past 17 years have been in my present position as Director of the Gaming Commission, where now I oversee 9 gaming facilities comprising of over 3,500 employees and 5,000 gaming machines, as well as oversee a staff of 48 individuals that help me do the job that I do. In this past 11 years, I've been able to serve on 2 tribal advisory committees with the NIGC, the first Mixed Revision Committee in 2001, and most recently, the Technical Standards Advisory Committee that was engaged in 2003. And as Michael stated earlier, I do serve as chairman of the National Tribal Gaming Commissioners and Regulators Association, where I'm presently serving my 2nd term. And the NTGCR represents 60 tribes from across the country. And the mission and purpose of the NTGCR is to assist tribal regulators by providing training and the exchange of information and experiences. The Cherokee Nation started gaming in 1989, and we started with 1 gaming facility, 1 small bingo hall. Over the years, we added a number of facilities, and now, as I mentioned, we operate 9 facilities. We have seen the evolution of gaming since its inception under IGRA. And when I first came to my position, I had no previous experience in gaming. I followed gaming on the fringes due to my capacities in self-governance and also in the Chief of Staff's office, but I did not have the experience that I knew that I needed. And taking a page from Michael's book, the first thing that I did, besides pull out IGRA and give it a good thorough reading, was called my tribal counterparts. I too called Tracy Burris, Bruce Longhorn, and a number of other notable individuals in Oklahoma gaming regulation, and began to formulate my basis and my understanding of gaming regulation. And what I brought to this position is sort of a philosophy that I had learned from my boss when I worked in the self-governance office. And he told me that one day he said that he gets no greater satisfaction from doing his job than knowing the regulations better than the federal counterparts and being able to beat them at their own game. I took that philosophy and applied it to my position here and took a very hard study of not only IGRA, but all the available information that was pertaining to gaming regulation. That included court cases, advisory opinions from NIGC, legal opinions, and numerous other documents. As I said, in the Gaming Commission in the Cherokee Nation, we have seen the evolution of Class II gaming as we know it today. As has already been testified earlier in the previous days, the Cherokee Nation was also involved in some pivotal cases that have brought us to our current state, and those are primarily the Megamania cases. We were one of the tribes that had a unscheduled, unplanned, and unwelcomed visit by our U.S. Attorney's Office on New Year's Eve 1997, where he promptly shut down the few Megamania machines that we had. The tribe itself fought those determinations, and it fought those based on the process that it followed to come to the conclusion that the games that we were playing were authorized and covered by the IGRA. Michael enumerated 10 best practices for Class II gaming. Those are the very same practices that we've used for these past 12 years since we first initiated electronic bingo games with Megamania. We required the vendors to submit a full description of how the game plays, all of its available features, everything that we needed to know about that particular game. We also required the vendor to submit a legal opinion attesting to the validity of the game description and the legality of the game under IGRA. Management, likewise, was also required to supply a legal opinion about their understanding and use of the game. And one aspect that Michael brought out that is that in his research, the tribes that he talked to, that's very key, as that's the same practice that we used as well. Once we saw a game that was being offered to us or requested from us, we immediately sought to find out whether or not that game was being played by another tribal jurisdiction or if it was being reviewed by another tribal jurisdiction. Contact would be made with that tribe if it happened to be in either of those two cases, just to see exactly what was being looked at, what was being offered, and what was being told to those other jurisdictions. In addition to the documentation phase of this, we also required a live demonstration of the game, where we verified all aspects that are included in the game description as well as the various legal opinions. These various pieces of information were documented and supplied to our own legal counsel, who reviewed all information and provided an independent and unbiased review of the game, either in support or in denial of its approval. The 4 criteria that Mr. Witt enumerated yesterday were at the heart of our review as well. We wanted to make sure that we could successfully defend a game, and by we, I mean myself and my staff, and defend it. We not only wanted to defend a recommendation for approval to our Gaming Commission, but we also had to be able to defend that recommendation outside of the Gaming Commission, in court if necessary. But we wanted to make sure that the game was connected to a server, that the game resided and was played through the server, that you needed a minimum of 2 players to initiate the game. The math that was being used was based on traditional bingo ball draws. And if you unplugged that game from the server, did it continue to play or did play cease? Once we had all of the information that we could muster on the particular game, we would make that recommendation to the commission, and the commission would make the decision on whether or not that game constituted a Class II game that is offered and protected under IGRA. Once that decision was made, the Gaming Commission standard practice was to notify the NIGC. We have made this determination. We are going to play this game. At times, NIGC would differ with our logic, would not accept our opinions, and would sometimes throw down advisory opinions that try to set the basis for their disagreement. And please remember, and I don't know if it had been covered yet or not, but the advisory opinions, as was stated earlier, were not necessarily done by the chairman. The last one I think that was actually done by the chair was back when Ada Deer was acting. All the rest of them came from the OGC, the Office of General Counsel. It came from the Gaming Commission legal staff and did not carry the weight of a final agency action, but were nonetheless being used to enforce NIGC's position on whether a game was or was not Class II. And on the heels of the work product that was produced by the Class II Gaming Consortium, the NIGC in 2003 formulated a technical standards advisory committee of which I was selected as a member. At the onset, we were initially told we were going to be charged with developing technical standards, the who's and what's and how's of how a game is going to be constructed, not how a game is going to be played. As we processed or proceeded down the path of developing the technical standards, the NIGC added to the Tribal Advisory Committee's responsibility by also including classification standards and a proposed change to the facsimile definition. Also along the way, we came to the realization that internal controls were also going to be affected by the technical standards. At the onset of the meetings, and this is very important for everyone to note, when we started the meetings of this advisory committee, Chairman Hogan told the group that it was his intention to quote-unquote get a handle on Class II. That was his basis for developing what he called the bright line. From the very first meeting, tribal regulators around the table told him the bright line is already there. All you have to do is look at IGRA. All you have to do is look at the court cases that have been decided. Along the way, we met various obstacles and challenges, and we were able to finally, after a long, arduous journey, come to a point where the NIGC published some regulations. And through the leadership of our tribal leaders and through a united front from all those in the Indian gaming industry, confronted NIGC and successfully challenged them on the validity of their regulations, by which they immediately and wisely took a step back, and that formed the basis of what's been called the Gaming Working Group. After a year of countless hours, countless conference calls, countless trips, the working group came together and presented what it considered to be a viable set of gaming regulations. Those regulations were accepted, but not completely accepted. They were accepted in name only, not in the content. Once we received the revised product from the NIGC, there were discussions about why some changes had been made and why we were still being looked at to weigh in on classification standards, which we felt we had no authority or business addressing. We asked NIGC where the criteria for these standards came from, and I recall receiving two answers. One is they were based on previously approved or previously determined Class II games. They referenced the Mega Mania game that was originally approved or determined, as I said earlier, in 1997, 1998. But the second response is the one that troubled me the most, and that was, we thought these were appropriate. We've had discussions of the executive staff, and we felt these criteria were appropriate for determining a Class II game. There was no legal basis, there was no statutory basis for what was being offered to us. After the work of the Tribal Advisory Committee and the continued efforts of our tribal leadership, NIGC did withdraw the classification standards and the proposed facsimile definition, hopefully due to the input that we provided them and in recognition of the fact that the bright line that the chairman so desperately wanted to have was not only already present, but was further defined by the technical standards and the resulting Class II mix. These efforts are just but one piece of the evolutionary steps that we have taken along the way in Class II gaming. These efforts would not have been possible without the leadership of our tribal leaders and the ability of regulators such as yourselves and others across the country in demonstrating your ability to properly interpret the meanings of IGRA and have a working competency of gaming regulations. The IGRA says, and I quote, "Indian tribes have the exclusive right to regulate gaming on Indian lands." This is obviously the primacy argument that is being provided for tribal regulators as being the frontline defenders of Indian gaming. The IGRA also states that the NIGC is to have regulatory oversight and is to monitor Class II gaming activity. I did something that I think the NIGC might need to do every now and then, is that's consult a dictionary. I looked up the words oversight and monitor. Oversight in its basic form means supervision, watchful care. Monitor is to observe and to instruct. I think the NIGC has lost its focus in recent years by becoming more focused on becoming an active participant in gaming regulation rather than a passive participant in providing training and assistance to tribes that need it. It's absolutely critical that tribes have a strong, vibrant regulatory body that is able to be independent to make independent judgment calls. The approach that we take is different than those of our state and federal counterparts because we have a higher purpose. We're not bureaucrats in some government agency. We are the frontline protectors of our tribe and our tribal assets. We are answerable to our family, our friends, and the citizens that depend on the revenues that go into the services that they all depend on. It's our responsibility as tribal regulators to know as much as possible about all aspects of a gaming operation so that we may fulfill our obligations to our tribal citizens and tribal governments. Those obligations are easily summed up, I think, into two basic functions. These functions were listed by Michael just a little bit ago, but they are very important. They are to protect the assets of the tribe and to protect the integrity of the games. And at the heart of the gaming operations are the games. Yes, licensing of vendors and of employees and all other aspects that go into regulation are important, but without the games, there's no need for the rest. Class II gaming is the foundation on which many tribes have built their economic development efforts and must be protected. And you've heard that tribes were given maximum flexibility to use technology in the offering of Class II games. And in 1988, I don't believe anyone really understood where that statement would take us. But now there are those that say that technology threatens to blur the line between Class II and Class III. And I say that the game that was provided for in the IGRA is the same game that we have before us today, regardless of the presentation to the patrons. The technology used in Class II gaming has evolved over the past 2 decades and will continue to advance in the future. But what has remained constant since the inception of the Class II gaming concept is the criteria by which Class II games are evaluated. You must ensure that they are played for prizes. You must ensure that they are able to be covered and daubed when numbers or designations when objects are drawn, and be a game in which first person covering a previously designated arrangements are the winners. Those are the basic criteria. That has been the foundation of a number of legal opinions, or excuse me, court decisions that have been decided in the tribe's favor. Nothing else has been added, nothing else is needed. The tribal regulators have done an excellent job in perpetuating the philosophy that my boss in self-governance has shared with me. We've attained a high level of mastery of laws and regulations affecting Class II gaming, but this does not mean that we are experts. This is because the gaming environment is continually evolving and changing, and it's going to require tribal regulators to be lifelong students of our discipline. And Mr. Green mentioned yesterday that he can provide information and advice, but the decision on Class II gaming is ultimately yours as tribal regulators. This hearing, this exercise, is not for us to tell you what you should do or should not do, but is rather to aid you in determining what path you're going to take in your approach to Class II gaming. This is a prudent exercise that has been conceived and executed by a regulatory body that is striving to meet the challenge of ensuring your tribe has viable gaming options so as to continue to provide for your fellow tribal citizens. It also serves as a means to provide guidance to others that are facing similar challenges so that they too can make well-informed decisions regarding Class II gaming. It's very important for us to have the ability to confer with one another so that we can present the unified front that Michael so aptly voiced earlier. It is through those efforts that we provide the basis for tribes to successfully defend and continue to defend the most viable economic development engine that the tribes have seen in recent years. I thank you again for the opportunity to provide testimony at this historic hearing. I hope the testimonies you've received over the past 3 days will aid you in your gaming pursuits, and I wish you continued success. Wado.
Thank you, Mr. Hummingbird. Ms. McAllister?
Good morning.
Good morning.
I'm pleased to have the opportunity to
Can you
appear
bring the microphone closer?
kind of short, so. Better? I'm pleased to have the opportunity to appear in front of your commission today, and I applaud your effort that you have here. And I, like Mr. Hummingbird, and I'm sure a number of people who have attended these hearings, I've learned a lot of invaluable, I think, information that I'll be able to take away with me as well. A little bit about myself, my history leading up to, I guess, today is that I'm currently a member of the Green Law Firm and have been for approximately 12 years. During my 12 years with the Green Law Firm, I had an opportunity to participate in a couple of the cases that have been discussed at length, I think, before this commission, the multimedia case, and one of the multimedia cases, and the Seneca-Cayuga case. Also, I was a gaming commissioner for the Eastern Shawnee Tribe for approximately 5 years. 4 of those years was a regular term, and another year as a holdover, while they attempted to find a tribal member that could take that position. And I think that was an excellent thing for the Eastern Shawnee Tribe, and we all worked together to accomplish finding someone that was a tribal member of the Eastern Shawnee Tribe, and eventually did, and I think made a very excellent choice in a upcoming tribal member. Throughout the or at the commencement rather, of my tenure as gaming commissioner at the Eastern Shawnee Tribe, I recognized that maybe, even though I had some experience in gaming at that point and had been around to participate in some of those cases, I still felt like that I maybe needed some more practical training, and I did receive training from that NIGA puts on, the National Indian Gaming Association, and the commissioner's training. I've also attended in furtherance of just some practical learning. I think that every person, every regulator needs to have. I attended some classes with the University of Nevada. And so I think that seeking of those sorts of just practical tools are necessary for regulators. And I did attempt to obtain all of the extra practical learning that I could. And I'd point out that most of that was from tribal sources. You know, our National Gaming Association, the Oklahoma Indian Gaming Associations. Little or none of my training came from anything provided by the NIGC. As a part of being a gaming commissioner at the Eastern Shawnee Tribe, I had the experience of really presiding over a commission that was very small. It was myself and a deputy, and during my term there, the gaming operation doubled. Went from a very small facility with some paper bingo and a few machines to a very large facility with all machines and a very, very large paper bingo area as well, much like what you have here at Sycuan. And it was a very, it was an explosion, really, of our gaming. Part of it was due to just the advancement in technology of Class II games, and also the state of Oklahoma beginning to enter into compacts with the tribes, you know, and really I can tell you that my experience in participating in developing some of those compacts, you know, I understand that, you know, any compact that a tribe enters with a state necessarily turns on money. You know, the state is seeking additional revenue. There's no way around it. And it really is the equivalent of, to some extent, maybe greater or less, just depending on the state, it equates to an erosion of sovereignty. And, you know, that's an issue that regulators, you know, have to work with. But it heightens and underlines the importance of our Class II gaming and why it's so necessary to maintain the Class II market that we have. Also, as a commissioner, I had a sort of a unique, or at least unique, experience in Oklahoma, I think, of engaging the NIGC in the process of game reviews. And one of those, by my request, I asked the NIGC to assist my commission in making a game determination. At the time, there were vendors seeking those game opinions independently from the NIGC, and I felt like that as a regulator, it would benefit me and our tribe to jointly engage with NIGC to maybe work to a conclusion about whether a game was Class II or Class III. So as a part of that, the first one actually that I initiated with the NIGC was a game for a manufacturer known as Cadillac Jack. And actually, I have to say that although I did not agree with the changes that were required in gameplay, there was an exchange of information. That we actually had meetings with myself, the technical people for the vendor and the vendor, and NIGC staff. And at the end of that process, it was over a period of a few months, at the end of that process, we actually did end up with a Class 2 game opinion of that particular game endorsed by the NIGC, or at least we think so. And so, since that game review worked fairly well, we thought, I thought, in spite of our disagreements with NIGC, then I initiated a game review for a game called Lucky Lotto. It was manufactured at the inception, I believe, by Worldwide Gaming Technologies, but now is known as America Gaming Systems, AGS. And this one was remarkably different, and I bring this issue to your attention today because it's relevant to the materials that have been provided to this commission for consideration in your fact-finding process, in that a response letter to me in regard to the Lucky Lotto game is contained within this binder that actually contains around 61 items. And I haven't reviewed every one of them, but I bring this up for your attention because I believe that this commission will review these documents submitted by the NIGC, and I think that you should be aware that in the process with AGS, it really there was no government-to-government review. And I have looked at this, have not read every item, but I note that it contains various things. And I'm referring to this document submitted by the NIGC for your review. And it's, there's some things that I think bear noting about this. And that is that, first of all, as expressed in the letter from the NIGC, you know, this book of information for your fact-finding was actually not submitted upon the endorsement of Chairman Hogan, not by the legal counsel, general counsel for the NIGC, really not even by a staff attorney. And in fact, this letter submitting these documents that the NIGC believes that you will find crucial to your fact-finding process. And I use the term crucial because that's what it says in the cover letter. This document is actually submitted by a legal staff assistant. You know, and I don't know precisely what exactly the NIGC's intent is, but I will say this. This is a sampling, based on my review of this notebook of advisory opinions that have been issued that the NIGC does not stand behind. Incomplete, in which I'll talk about a little bit more in regard to my AGS game review. And it's disturbing because it's a problem for regulators. It is virtually impossible, and you've heard testimony from other panels, I think, on this issue, but it's virtually impossible to rely on any opinion that's put out by the General Counsel of the NIGC because Chairman Hogan never stands behind those as a formal action of the NIGC. And in fact, I did, and I think Jess alluded to it a little bit yesterday in his discussion, but I did find a quote, and I think that should be considered along with these materials that's submitted to your commission. And this is a quote from Chairman Hogan, and it can be found in the International Gaming and Wagering Business Magazine, Volume 24, Number 11, and it was the publication of November 2003. Chairman Hogan says, in response to his decision that mechanical reels were available for play, and I think there's an advisory opinion on that. When he was questioned about that decision and that action of the NIGC, his response was, "The NIGC hasn't decided anything yet. The Office of the General Counsel and the NIGC has issued an advisory opinion. Certainly, the Office of General Counsel takes guidance from the Commission, but this advisory opinion was not a product of formal or full-scale Commission proceedings." This is just one example of his refusal to stand behind or even acknowledge that the NIGC has participated in these advisory opinions. And it appears as if that these opinions are randomly, I guess, drafted by General Counsel for the NIGC with no approval of the chairman or the commission as a whole. So, in these materials contain a lot of things, and I could not honestly say that I've researched, and I don't believe it contains every advisory opinion of the NIGC. I think it's a sampling, a really curious sampling of documents produced at some point or another by legal counsel of the NIGC, and I question the value and benefit to this commission, but of course that's up to you to decide. For purposes, though, of completeness of this document, at least number 7, which is a letter in regard to AGS that was addressed to me, I have brought for you the remaining letters. I think this is sort of a disingenuous inclusion of an opinion issued by General Counsel, acting General Counsel of the NIGC to me, and I would like to explain this a little bit. And I would also like the Commission to have the complete set of documents, because this game is actually, at least in Oklahoma, a very important game for the tribes. It's has been a lucrative Class II game. And this particular document, this number 7, included in the NIGC materials, is a preliminary opinion to me, and you should note it's dated at the top, April 22nd, 2005. And the materials that I will provide to you that supplement this point out that I made the request in October of 2003 for the NIGC to assist me in review of this game. No response was provided until April 22nd, 2005. There was no government-to-government communication in regard to this game in spite of my request. And I think this is an example also of a violation of Department of Interior policies on joint consultation. At any rate, I initiated the request in 2003. I received a response from Penny Coleman in 2005 that this game is Class 3 based on proposed regulations of the NIGC, and I just want to point out to this commission that these regulations never came to fruition. They've never been published for comment. They're not in existence today, and it's very bizarre, in my opinion, to issue a classification opinion on a game, and your opinion is based on rules that are yet to exist. And so, in follow-up communications on this particular game, which are not included, this opinion was withdrawn in a sort of backhanded way. There was an apology to me for not following exactly the consultation process and but it was also pointed out in that letter that they still thought, based on these proposed regulations, that this would be a Class 3 game. And I, again, remind you that those regulations aren't in existence. And I think you'll find that the remainder of these documents, or a big majority of them, include that sort of thing. In regard to this one particular submission to me, I do have, for the Commission's review, the complete record, at least as I have it on this game. I would point out that this game review was never completed. I requested in 2003, had a response in 2005, some follow-up communication by letter in 2005, and then no other response from the NIGC. It's came to my attention based on a FOIA request that now the NIGC, in spite of no communication with the tribes, even though I'm no longer the gaming commissioner for the Eastern Shawnee, there wasn't communication with that commission in regard to this consultation that I had started and requested. And there's evidence in the FOIA request that, in fact, they've drafted a new opinion for this game that we can expect maybe to come out at some time or another, and that they've requested the remaining commissioner at the Eastern Shawnee to terminate this thing. So terminate the government-to-government review process. And so it's a very puzzling and certainly not action or a document or a communication, any of these that you can rely on with NIGC, and it's unfortunate as regulators that that's the position that you're in. But I would ask that you keep this in mind. In regard to, there was some comments, I think yesterday, and about the steps that we went through to classify a game as Class 2, and I think that's been more than adequately addressed here by the other panelists. But I would add to this one requirement that I included as a commissioner is that the vendor, in addition to providing a lab report, in addition to providing the attorney opinion that it's a Class 2 game, and in addition to our counsel agreeing that this is a defensible game and our observation, in addition to all those things that have already been listed, I like to obtain from that vendor a commitment that they would pay for litigation if it should arise in regard to their game. And that's not certainly not an undertaking to be taken lightly, as any of us who's participated in any of that litigation knows. I think that helped protect the tribe's resources and assets. So it may be something to consider. Also, I would ask that maybe when the commission is thinking about, there was a question yesterday, and I don't remember which commissioner asked it, but it was in regard to effects on other tribes. And I agree with Mr. Hummingbird that it's very, very important, if at all possible, to work with other tribes. And in regard to that, I did have a regulation that I could accept another tribe's classification opinion of a game. And obviously, that wouldn't extend to everyone. I think probably within your commission, you're going to have information about the other commissions that are nearby to you, and whether or not you felt like that was a full and fair evaluation of the game would be within your discretion, but it is an option and a way to work with other commissions on game reviews. And you know, I did have occasion as a commissioner to be presented with games that I felt like I didn't think were defensible. I felt like that maybe they weren't Class 3. And in my evaluation of them, I just wasn't comfortable. And so rather than write an opinion or refuse their license or do something that might have an impact on the other tribes around us, because I can think of a couple of situations where other tribes were playing that game and they felt comfortable with it, and I didn't want to penalize a vendor or cause any sort of bad effect for them if that's their decision. So, you know, I would point out to you that there are options for you to consider when you are in a position of having to make this determination, and you know that your decision might affect someone else. An option, one thing that I employed on occasion was just to have a suitability hearing with the vendor in private. Usually it resulted in that game being withdrawn and their application being withdrawn without having repercussions for other tribes or the vendor. So, in regard to, you know, the rules that I employed, and I believe that you should employ when looking at games, I think, you know, those have been enunciated very well by Mr. Lombardo and Mr. Hummingbird, and so I'll not belabor that point. And I would say that, you know, a simple way to look at it was expressed to this commission by Mr. Witt. I fully endorse his 4-step process and ask that, you know, you take a look at that. When you're looking at ways, a simple classification method, I don't know of one simpler. So thank you for your opportunity here to speak, and I hope that you know, that you all take away from this something of value. I know that I have.